Hey guys, so I apologize if I sound really irritating and nasally in this video. My sinuses freak out at this time of year, and there's not a lot I can do about it. So yeah, I'll probably sound nasally. I apologize if it gets under your skin, but there's not a lot I can do about it, so if you can't deal with it, you're probably just going to have to leave. Whatever the case, in this video, I am going to be discussing an argument which is often employed by men's rights activists and pro-choice activists who want to alleviate themselves of their parental obligations to their respective offspring, be they pre or post delivery. It doesn't actually matter because this argument applies equally well in either instance. But essentially what they'll do is they'll come out and they'll say there's a difference between consenting to sex and consenting to parenthood. So I cannot be held responsible as a parent even though my status as such is a direct consequence of my decision to engage in copulation, because that's not what I decided to do. I decided to have sex, not to be a parent. Therefore, you cannot hold me responsible as a parent. Now, I don't think that this argument holds water, because while I will not challenge the truth value of the premise and do agree that consenting to sex is not tantamount to consenting to parenthood, it doesn't have to be. That's not the standard we use, and that's not the standard that we should use. Let's apply that in some other aspect of the law. Let's say we're dealing with torts, and you want to file a tort against somebody who hit and injured you while driving under the influence. Okay, you have a right to compensation for the damage to your body. However, if we say that only when someone specifically and directly consents to something can they be held responsible for it, you have no way to get compensation from this person. Because while he may have consented to driving under the influence, that's not tantamount to consenting to injuring you. Therefore, he has only to say, I didn't mean to do it, and he is relieved of any responsibility as a drunk driver. Now, you can still get him with a criminal charge for driving under the influences because that's also against the law, but you can't file a tort and you're going to have to pay your medical bills all by yourself, even if you can't afford them. Yeah, we obviously don't want to use the standard. It obviously doesn't work. It obviously creates some serious problems. So what standard do we use? Which standard do I endorse? Well, the answer to both of these questions is the reasonably foreseeable standard. Basically, in our current legal system, if the consequence of an action was reasonably foreseeable, you can be held responsible for it. So if you drive under the influences, it is reasonably foreseeable that you will hit and probably hurt somebody. Therefore, you can be held responsible for that. Now, on the other hand, if you go out and get in your car, and while you're driving along, an owl swoops down, crashes into your window, and causes an accident, you can't be held responsible for that, because how are you supposed to know that owl was going to swoop down and smash into your window? It's not your fault, and you shouldn't be held responsible for it. Okay, that's just fine. But if you apply this to the area of parental obligations, you will find that parenthood is definitely a reasonably foreseeable consequence of engaging in copulation, since that particular activity is specifically and biologically designed to engender parenthood. Therefore, this argument doesn't hold water because it doesn't apply to the standards of our legal system, and it doesn't apply to the standards that our legal system should employ. Now, that's not to say that there are no circumstances in which we can escape the consequences of our actions when they are also reasonably foreseeable. For example, I can smoke for 20 years, and if I develop cancer, that is a reasonably foreseeable consequence of my decision to suck on the little death stick. However, I still get to have my tumor removed. You're not going to say that because I smoked for 20 years, I should be restricted from receiving medical attention. No, hardly. No one's going to condemn me to a horrible cancerous death because I decided to smoke. Why not? Well, because I don't have to bring anyone else's rights or interests into the equation in order to have that tumor removed. I can have that tumor removed without hurting anyone. It will cost me money, it will go onto my insurance, and you will go on living your merry life. Now, on the other hand, when we're dealing with child support, you're going to hurt your baby mama, you're going to hurt the child, and you have created a situation such that someone is dependent upon you for their continued existence. Therefore, you do have the obligation to provide for them. You do have parental obligations. At the same time, if we're looking at abortion and we assume, again, we're assuming that the fetus is a person or at least something which deserves the same rights as a person, then once again, you've created a situation where in order to exercise what would usually be a right for you, you must violate somebody else's rights and therefore do not get to do so. So this argument does not hold water.